100 words per minute for 10 minutes. 5 seconds more. Start. Life and death as concepts have invited many a thinker, philosopher, writer, and physician to define or describe them. The perception is not always the same at every stage. There comes a phase in life when the spring of life is frozen, the rain of circulation becomes dry, the movement of body becomes motionless, the rainbow of life becomes colorless, and the inevitable death comes near to hold it as an octopus gripping firmly with its tentacles so that the person shall rise up never. Mere existence does not amount to presence. Sometimes there is a feebleness of feeling of presence in semi-reality state when the idea of conceptual identity is lost, quality of life is sunk, and the sanctity of life is destroyed. The question that emerges is whether a person should be allowed to remain in such a stage of incurable passivity, suffering from pain and anguish in the name of hippocratic oath. In contradistinction to the same, the question that arises is, should he not be allowed to cross the doors of life and enter painlessly and with dignity into the dark tunnel of death, whereafter it is said that there is resplendence. In delineation of such an issue, there emerges the question of law: should he or she be given such treatment which has come into existence with the passage of time and progress of medical technology, so that he or she exists possibly not realizing what happens around him or her, or should his or her individual dignity be sustained with concern by smoothing the process of dying? There is also another perspective to it. A family may not desire to go ahead with the process of treatment, but is compelled to do so under social pressure, especially in a different milieu, and in the case of an individual, there remains a fear of being branded that he or she, in spite of being able to provide the necessary treatment to the patient, has chosen not to do so. There has to be a legalistic approach which is essential to clear the maze and instill awareness that gradually melts the idea of meaningful guilt and ushers in an act of affirmative human purpose that puts humanness on a high pedestal. However, in an action of this nature, there can be abuse by the beneficiaries who desire that the patient's heart should stop so that his property is inherited in promptitude, and in such a situation, the treating physicians are also scared of collusion that may invite the wrath of criminal law as well as social stigma. Therefore, the heart of the matter is whether the law permits for accelerating the process of dying sans suffering when life is on the path of inevitable decay, and if so, at what stage and to what extent. Various learned counsel appearing before us have submitted that seeking declaration from the High Court in cases where medical treatment is needed to be withdrawn is time taking and does not advance the object nor is in the interest of terminally ill patient. It is submitted that to keep a check on such decisions, the state should constitute competent authorities consisting of predominantly experienced medical practitioners whose decision may be followed by all concerned with a rider that after taking of decision by competent body, a cooling period should be provided to enable anyone aggrieved from the decision to approach a court of law. We also are of the opinion that in cases of incompetent patients who are unable to take an informed decision, it is in the best interests of the patient that the decision be taken by competent medical experts and that such decision be implemented after providing a cooling period of at least 1 month to enable any aggrieved person to approach the court of law. The medical team, by taking decision, shall also take into consideration the opinion of the blood relations of the patient and other relevant facts and circumstances. The petitioner, by the writ petition, has also sought a direction to the respondent to adopt suitable procedures to ensure that persons of deteriorated health or terminally ill should be able to execute a document titled My Living Will and Attorney Authorization. The petitioner submits that it is an important personal decision of the patient to use or not to use the life-sustaining treatment in case of terminal illness, persistent vegetative state. Learned counsel for the petitioner as well as for the interveners and the additional Solicitor General of India has expressed concern regarding the manner and procedure of execution of advance medical directive. It is submitted that unless proper safeguards are laid down, those who are vulnerable, infirm and aged may be adversely affected, and efforts by those related to a person to expedite death of a person for gaining different benefits cannot be ruled out. From the above discussions, we arrive on following conclusions. We are of the opinion that in cases of incompetent patients who are unable to take an informed decision, the best interests principle be applied and such decisions can be taken by specified competent medical experts and be implemented after providing a cooling period to enable any aggrieved person to approach the court of law. An advance medical directive is an individual's advance exercise of his autonomy on the subject of extent of medical intervention that he wishes to allow upon his own body at a future date when he may not be in a position to specify his wishes. In view of our conclusions, as noted above, the writ petition is allowed in the following manner. A person of competent mental faculty is entitled to execute an advance medical directive in accordance with safeguards as referred to above. Before we conclude, we acknowledge our indebtedness to all the learned advocates who have rendered valuable assistance with great industry and ability which made it possible for us to resolve issues of seminal public importance. We record our fullest appreciation for the assistance rendered by each and every counsel in this case.